Number 79, the people of the state of New York versus Everett Balkman. Counsel?
Thank you. My name is Janet Soames. I represent Mr. Balkman, and I'd like to reserve 2 minutes for rebuttal.
You may. Counsel, I have a question before you start. Are you arguing that the police can't stop a driver based on a DMV similarity hit, or are you arguing that there was a failure of proof on the part of the people?
There's a failure of proof on the part of the people here.
Thank you.
Sustaining the stop in this case, under the facts of this case, cede a determination of reasonable suspicion to a computer program about which we know nothing, except that somehow it uses a name, date of birth, and aliases to issue some sort of notice about the similarity between the registered owner of a car and a warranted person.
So
It also
I'm sorry, I'm over here. I know it's difficult. Just to clarify on this point that you're making right now, is it that you're saying that the prosecutor had to put in proof about how this system works, or just what was visible to the officer?
I think that the prosecution could have done either, but they did neither. And therefore, we don't have objective facts on the record from which...
Well, if it's just how it works, it doesn't tell you what the officer actually saw.
We need what the officer saw.
Right.
I assume that if the officer...
So do you really need to know how the whole system works, if all you really want to know is what did this officer see at the time they made the choice to stop the car?
I think that what the officer saw is one way. I think that if there was proof about how the system worked, then possibly if the officer here had said that he assumed there was a warrant based on the similarity hit, or that he believed there was a warrant, then there might be some proof in the record to support his belief, but we don't have that here.
Do you need something about the accuracy, the rate of false positives, something like that?
That would be one way that they could also establish the reasonableness of the officer's belief, if he had such a belief, because here he didn't say he believed it. But we have no idea what the accuracy rate is. We don't know if it's 1 in 1,000 returns an actual warrant. Is it 1 in 500? We have no idea on the basis of this record whether or not there is any likelihood, or what the likelihood might be, that the warrant is actually for the registered owner of the car. So this record, we don't know the name of the person with the warrant. We don't know the name of the registered owner. We don't know what the supposed similarity was. We don't know what he saw on the screen. But what we do know is that he had literally at his fingertips the means to find out whether or not there was a warrant for the registered owner of the car. But he didn't look at that information. Now, the people they argue that it's not safe for him to do so while driving. He didn't have to do so while driving. He could have radioed to someone and asked for help in ascertaining whether there was a warrant. He could have followed the car for a while.
Wouldn't that also go, I mean, I think to Judge Rivera's point, it really would depend on, let's say they did come in and say, look, there was a warrant out, same name, bank robber, 5 minutes ago. Would you really have to go check? Or in that situation, could you just pull the person over? I mean, wouldn't it really depend on what's on the screen?
I think it does depend on what's on the screen, yes.
And I mean, I take your point that there's pretty much, we don't know anything about what was on the screen here, except maybe I think that the warrant was out of Rochester, right?
The warrant was out of Rochester, yes. That's about all we know.
What if the police officer stopped him, then went and looked, read what was on the screen, saw that it didn't seem to be a match? Wouldn't that officer either have a responsibility to, or at least be able to, walk over to the car and explain why they were stopped, and maybe apologize, or whatever? And then doesn't the plain view doctrine jump in here? And so I guess my question with that is that is your argument here, does that put limitations on the availability of the plain view doctrine?
I don't believe so. First of all, I think that if he pulled over the car and then he checks and finds out there isn't a warrant, he has no obligation to go up the car. That almost turns into an unreasonable stop at that point.
Well, let me ask you something different. What if the police officer saw something, a problem with the car that maybe the owner wasn't, the driver wasn't aware of, and wanted to make a safety stop? then the stop is okay, right? So are you suggesting that you can't do that?
I'm suggesting that once he realized that there's no warrant, he has no reason to continue to seize that car, and he can very easily drive by, wave, get on his loudspeaker, say, hey, have a good day, whatever it is. But once
So
he
at that
knows,
point, it would be improper for him to even walk over to the car to,
I believe it would be improper for him, because that is a seizure that is then continuing, and he has no basis to continue that seizure. What the officer did here, though, was takes you almost into Ingle territory, where he kind of nosed around the car. He was checking the registration, checking the inspection to make sure it was all legit, and there was no basis to do that.
So I know you're taking the position, as you've already responded to the Chief Judge's question, that there was a failure of proof here. But is there, from your perspective, a minimum? Is there a floor, at least? Or it's always a case-by-case determination? Is there something that, from your position, you would argue, look, that's the minimum, you got to have that. If you have more, that's a different story.
I think that at a minimum, when it comes to the reasonable suspicion issue, at a minimum, there has to be evidence in the record from which a reviewing court can take a look and make a determination as to whether or not the officer reasonably believed what he claimed to have believed, which again, he didn't even say that he believed there was a warrant here. So yes, I think that there is a minimum, and again, we don't have it here.
Thank you, counsel. Counsel?
May it please the court, Lisa Gray for the people. Good afternoon, your honors. In this case, the police officer presented specific and articulable facts at the hearing to establish that there was a similarity hit for the registered owner of the vehicle.
So what are the specific facts that you believe the evidence showed?
Well, he had information that the warrant was a localized warrant out of the city of Rochester. He had the make and model of the vehicle. He knew that the registered owner was a male, and that vehicle associated with the warrant was being operated in the jurisdiction out of which the warrant was issued.
But was the vehicle, I'm sorry, was the vehicle associated with the warrant? I thought it was a similarity on the name.
The police officer ran the plate through his MDT and revealed the registered owner of the vehicle as being similar to somebody with a warrant out of the city of Rochester.
Right, but there's no
How
connection
does the
to
reviewing court test that when you don't even know what the names are? One of the reasons I use my middle initial is because there's a lawyer who practiced in the same jurisdiction that I practice with exactly the same name. The only difference is our middle name. We don't know any of that information here.
Well,
do
the
we?
police officer did explain during the hearing that oftentimes these similarity hits do come from far-flung jurisdictions, Texas, California. In this particular case, not only was it narrowed down to the county of Monroe, it was narrowed down to the city of Rochester. And as he explained to the court, that gave him heightened attention to do his duty, which was to investigate that potential warrant of the operator of that vehicle or one of the occupants of that car.
Well, you gave, for example, the fact that it was out of the city of Rochester and the registered owner was a male. That's pretty broad. So how do we know that the requirements for having a similarity hit, DMV's requirements, aren't unreasonably broad so that it would capture, many people that it didn't apply to? How would we know that, and don't we need to know that?
Well, I think we do know that from the hearing, and that is that the DMV, the triggering mechanisms that the officer testified to include name, date of birth, aliases from perhaps previous arrests.
But we don't know how similar the names are. I mean, maybe the names had the same first letter of the first name and the last name, and that was it, and the names were completely different.
And in this case, the police officer was reasonable in pulling over that car in order to investigate that equivocal fact situation.
But how do we know that, I guess, is the point Judge Stein's trying to make. We don't know what the similarity was. We don't know if it was off by a letter, if it was a full name with an initial, if it was an age and date of birth match. We don't know any of that.
But we do know that it was a localized warrant out of the city of Rochester that had a potential similarity to the registered owner of the vehicle. And it was reasonable for that police officer to pull the car over in order to...
So why couldn't he, when he pulls the car over, though, do exactly what I think was discussed by one of my colleagues earlier, which is, okay, you pulled the car over, the car's pulled over, there's no indication the car's fleeing. Now read it and take a look at it, because he didn't want to do it while he was driving.
Because at that point, the seizure's already happened. The seizure's already happened. So whether or not the police officer sits in his car and
Yes, but it
reads
would
through information
dissipate
and synthesizes
either
it,
or raise, perhaps the quantum of information, wouldn't it?
it would, that would be no less of an intrusion on the operator, the occupants of that car, because
But
at that
it's
point-
more intrusive to actually go over, right? I mean, yes, of course, you've
in
got to
fact-
stop because you've stopped the car. No one's disagreeing with you, but isn't it even a heightened level of intrusion to actually get up, walk over to the car?
Respectfully, I would disagree, because in this case, the police officer told the court that it was between 20 and 30 seconds by the time he observed that loaded gun between the appellant's feet, whereas if...
No, but that's
if he-
already going to the car. I think the point was, once you make the stop, why not then look at the screen or do whatever other search you can to get a better sense of whether or not there is a basis for this stop.
He would be prolonging that detention of the occupants by looking through 25 pages of MDT material, synthesizing it, assimilating it. I think he said it took maybe about 20 seconds per page. So he would have been sitting there for about 5 minutes trying to figure out.
But we can't even evaluate that claim because that's not in the record, right? I mean, you could have printed the thing out and put it, do you know why it's not in the record?
He testified at the hearing that I believe there were about 20 or 25 pages of information that he would have had to read and synthesize and assimilate and then make a determination, all while driving and keeping the suspect car in view. And he told the hearing court that even doing that would have been difficult. This was a limited intrusion, a 20 to 30 second interaction with the driver. And he tells the driver, listen, the registered owner of the car may have a warrant, and she informs him that it's her brother who's the registered owner. He also knows that there's an adult male in that car.
Isn't he more likely to get untainted information by looking at those pages?
I mean, not necessarily.
As opposed
I
to
mean,
what someone may or may not tell him?
Not necessarily. We certainly know that there are cases out there where police officers have relied on MDT information that turns out to be stale or, resolved information that the DMV just hasn't updated in their computers, but that isn't the case here. So it was in his discretion to do a limited intrusion of a quick car stop, much like a show-up procedure.
The similarity could be stale too, right?
I'm sorry, Your
The
Honor?
similarity, it could be stale too?
In this case, it wasn't. He was able to determine that the registered owner did not have
But
a
it
warrant.
could be. It's
but
sort
the
of
warrant was-
following your analysis of a case. It could be.
Yes, but in this case, that's not in this case. I mean, there was a warrant, it just wasn't for the registered owner of the vehicle.
Let me ask you this, if you do that, just that similarity hit, maybe all you realize at once is that the owner is male, okay?
Yes.
You stop the car, you start walking, you see that the driver's female alone. I know in this case there were two other men. What should the officer do?
Well, again, I think that goes back to my previous point, that at that point, the limited seizure has happened. He's allowed to address the driver. He has that short conversation with her. Those are reasonable steps to investigate this particular warrant and where that wanted suspect is, whether or not it's the
But
operator
learning
or
what?
the
I mean, doesn't
occupant.
the officer still have to confirm that indeed the warrant is for the owner of that car?
Yes, he does, and he did that in this case.
But what I'm
in
saying is,
fact, it
how's he
wasn't.
going to get that from her? So what's the point of asking her in my hypothetical?
Because he had a duty to investigate that warrant. So she's the operator of that vehicle. He immediately tells her, listen, you're not the subject of the warrant. I know it's a man. And she volunteers information about the registered owner. So he is in furtherance of his duty to do that investigation.
And if she doesn't want to talk to him, what happens next? She says, I don't have to talk to you.
Then I think that at that point, he could perhaps ask for identification of the other people in the vehicle.
No, in my hypothetical, where she's alone, and obviously is not the owner, because the owner is identified as male.
I think under that hypothetical, if she's alone in the vehicle and he
Yes.
knows that the registered owner is a male, then
Yes.
then at that point, probably he could say, have a nice night and be on your way. female operator. But that's not what happened in this case.
No, I understand.
So what would happen if in that very, very brief period of time, he looked down on the floor and saw a firearm?
I'm sorry, Your Honor. What?
So what would happen if, in that very brief period of time in which he...
Again, I think the analysis is still the same. At that point, he would be lawfully present in order to make that observation. He does see that the operator is female versus, let's say, a registered owner who's a male. But he's lawfully there, but he doesn't even get, in your scenario, he doesn't even get a chance to wave her on because now he has seen evidence of contraband in plain view. He's lawfully present under the other scenario, and he would wave her on, but now he sees contraband, and he would be lawfully present. He's still lawfully present at that driver's side window.
Can I ask you, a lot of times in these cases, even though they're so fact-intensive, there's a snowflake-like quality to them, usually a series of factors that a court can look to evaluate them. What factors would you have us to look at in this similarity hit problem to establish that there was reasonable suspicion?
I think the factors that this court should look at are the...
Let's say in every similarity hit type, these kind of problems of identification through highly technical computer programs are going to become more prevalent rather than less prevalent. That's why I'm asking you, because this case really could carry over and have more effect beyond simply this particular stop.
I think generally the factors of what makes up the similarity hit, which was certainly explained by the officer in this case, in terms of the triggering mechanisms, the different criteria that would bring the information forth through the MDT, and the factors of the similarity hit in terms of whatever the particular similarity hit is based on.
You see the problem if you let's say you move into another type of technology like facial recognition technology, and the problem of similarity hits. You see how a lack of clearly defined factors that are set out and clear proof standards could really wreak havoc on all of our rights?
I believe the standard still remains, what is that quantum of knowledge the police officer had in order to establish reasonable suspicion? And reasonable suspicion has never required the police officer to establish with absolute certainty that criminality...
I think you're totally right, and that'd be unfair, and that would be a bad idea. We wouldn't be able to protect society in any way.
So
I agree with you. Yeah.
So police officers are at times presented with equivocal fact scenarios. So they do have a duty to investigate that. And the similarity hit is no different than facial recognition technology that may be used in law enforcement in the future. And in this case, the police officer had that quantum of knowledge. The people presented enough evidence at the hearing to establish that.
One of the things I struggled with is I had nothing to compare it to. You said it was similar, but it didn't seem like the record really established the similarity. The name, the warrant, the look of the person, none of that was in the record. It was difficult.
Well, again, I think we know that it was a localized warrant coming out of the city of Rochester. The police officer testified generally as to what those triggering mechanisms were. We had the registered owner as a male, and the car associated with the person who could have the warrant was being operated in the jurisdiction out of which the warrant was issued. So all of those things, the trial court correctly concluded, the appellate division affirmed that gave rise to reasonable suspicion. Similarity hit based on a judicially authored warrant can give rise to reasonable suspicion and sustain a traffic stop in New York.
Thank you, counsel. Counsel?
Going to Judge Fahey's question, I think that your illustration of facial recognition is a good one here, because in order to be able to determine whether or not any hit was reasonable, you would need the two screens, the two screens of the face, so that you can make a comparison. And here, if they brought in the screens that the officer actually looked at, there would be a basis for comparison, but they didn't, and so there is not. The decision, below incentivizes the police not to look at readily available information, which will tell them whether or not there's a warrant for the registered owner of the car. And going to Judge Feinman's concern about why he uses a middle initial, if if a person is swept up in these similarity hits and they're not the person that has the warrant, then that person is going to be subject to being stopped over and over and over again. And he or she will have no means to clear it up because only the person with a warrant could clear it up and get it out of the database.
Thank you, counsel.